Today we're still talking about alimony, another piece of it. The party seeking alimony, how much can they earn? How much can they meet their own financial need? I'm Jaclyn Robertson with JR Law Group, and welcome to Family Law Friday. In cases involving an alimony claim, as we've discussed in the past weeks, once the party seeking alimony has enumerated their respective expenses, the next piece of the analysis is going to turn to how much is that person, that party, able to meet their own financial need. So there are some nuances within that we're going to talk about today to better clear up what that means. So in cases where, regardless of whether or not in recent years during the course of the marriage, the recipient, the party claiming alimony, has worked or not, that does not mean that they will not be imputed an income. So in cases where the recipient spouse is working, then we know what their income is, and that's clear, and that will be the amount that is decided they can provide to meet their own financial need. Now, where this becomes a little bit more unclear and requires more analysis, the court will then, if the party seeking alimony has historically not been employed during the course of the marriage, such as in cases involving children, where they may have sacrificed some of their career to spend time with the children, or, for various other reasons, then the court is still going to impute an income to the recipient spouse. So what does impute mean? It basically means the court is going to do an assessment of what you're capable of earning and assert that that is the amount that you're capable of meeting your own financial need. So in cases where the recipient spouse has a history of employment and specialized training and skill, then that will be turned to decide what they're capable of earning. Conversely, in cases where, say, there's been a party that has been home, taking care of the home and children for years, and perhaps maybe doesn't have specialized training and education in specific fields, then at a minimum, that party will be imputed or decided that they can earn minimum wage of 40 hours a week. So that amount will be the amount that will be deducted from their expenses as their ability to meet their own financial need. Now, in cases where the party is the recipient party's ability to earn a living and what that amount is in dispute, then the parties can turn to what's called a vocational assessment. And this is where you have an expert who specializes in helping individuals decide and look at their employment history, labor statistics, etc., to decide what that individual is capable of earning. Now, that is the general rule of thumb. In situations where, say for example, cases involving children, say there are, a few small children, and the couple would be facing the cost of childcare, then in that limited situation, the court could potentially not impute minimum wage to that party if they in lieu will be responsible for the full childcare, because sometimes in some cases the cost of childcare actually exceeds what the cost of, what you can earn in minimum wage full time. So that would be a case where the court may not impute income. Similarly, if there's disabilities or, other issues that are concern for an individual's ability to earn a living, then that will factor in. It becomes an issue for the court to decide, and the vocational expert will weigh in on that. So, and similarly, as for the vocational assessment, once the recipient spouse's ability to pay or meet their own financial need has been determined, there will also later need to be determined the payer spouse's ability to earn a living and what their ability, how much they can make. So if that's in dispute, that might be another scenario where a vocational assessment would become relevant. But ultimately, the recipient spouse is going to be assumed to be able to earn a certain amount of money, and that is their ability to meet their financial need. Another piece that will factor into their ability to meet their financial need is the child support. If the recipient spouse is also receiving child support, then their income as well as child support will be deducted from their listed expenses, or their total expenses, and then that will boil down what their financial need is. And from that, you take that amount and turn to the payer spouse to see what the payer spouse's ability is to meet their financial need. So hopefully this clears up just the idea of what the recipient spouse's ability to meet their own need focuses on. And one thing I will point out that also comes up often is if the recipient spouse didn't work during the course of the marriage that does not mean that they will be able to continue to not work. Some clients may think that, well, that was the standard of living. The standard of living is actually a different definition. While you may have enjoyed that standard of living of not working, the standard of living as far as, analyzing alimony doesn't mean you get to continue to enjoy or have that luxury of not working. It just turns on the standard of living factors in when you're listing your expenses. If you had certain expenses during the course of the marriage, it's very reasonable for you to continue to factor in those expenses in your current budget. And even if in some cases there's, some more luxury items, if you had that standard of living during the marriage, you continue with that. So that's just kind of a little distinction between, the misideas there are around what's standard of living means in terms of calculating alimony. So the idea is you will ultimately, one way or the other, be imputed an income, or there will have to be good reason for why you shouldn't be. If you have any more questions about alimony or about your own particular case, go to my website at jrlawgroup.com and schedule a consultation. Follow me on Instagram at jrlawgroup, and I'll see you next Family Law Friday.